am Lule Kwangobo. I am coming from Legal Campus Advisors. This is episode 2 of What to Do if you no longer want a matter to proceed and the matter is already in court. Like we've already said, some of these videos are going to have more episodes than one for fear of bombarding you with information. Now let's continue. Again, like I've said, you no longer want the matter to continue. However, the matter has already been placed on the roll and the prosecution is basically ready to prosecute and go ahead with the matter. Another way to go about this is to go to the station where you open the case and request the investigating officer handling the matter to put what we refer to as a withdrawal statement. So it's basically an affidavit under oath where you yourself say, I have forgiven the accused person, or he has compensated me for the loss suffered as a result of his offense against me, and I now no longer wish to proceed with the matter. The investigating officer will assist you in drafting this affidavit, or ensure that it's commissioned, and will inform you of the next court date, which you must then attend. Because if you are not there, the prosecution shies away from withdrawing matters purely on the statement that they find in the docket. It's always prudent, and which is what we always do, to call the complainant, let them attend the court, and come to confirm that this is indeed what they want to do. So make sure that on the next occasion, even though you've written a statement, or rather an affidavit to the effect that you now no longer wish to proceed with the matter, come and assure the prosecution, come and sign the relevant documentation to say that you are now withdrawing. This is another way of also withdrawing the matter if you no longer wish to proceed. And again, the prosecution also reserves the right to withdraw matters, mainly in two situations. One, what we call a provisional withdrawal. Now, when we say provisional withdrawal, we are definitely saying that the matter is coming back. It's either we are short of investigations, there's still certain information that we need in order to prove our case in court, or we still need to trace certain witnesses and cannot proceed without those witnesses in proving the charges in court. So there's many ways in which the matter can be withdrawn. However, a provisional withdrawal means that we're still coming back with the matter. You must expect a subpoena or communication from the court when you need to attend once the matter is re-enrolled. The other one is a straight withdrawal, either on merits, meaning that there is not enough information or there is not enough evidence for us to prove this case, or sometimes what we refer to as on a humanitarian basis. For example, it is a very old man. He is 95. And perhaps when he was committing the crime, he was not in his right state of mind. Perhaps he was going through a lot of stress. And after explaining it to the senior or control prosecutor, the prosecutor understands that it was never the intention of the accused person to commit such a crime. And on a humanitarian basis, the charges are withdrawn. Now, this is not to say that all matters qualify for such a withdrawal. The qualifying word there is humanitarian basis. There must be humanitarian grounds on which we can withdraw the matters. Others that we've seen, again, for example, for an elderly person that's committed the crime, there's enough evidence pointing to the fact that they've committed the crime. However, they are a first-time offender. Even in cases of youngsters, they are first-time offenders. You can see either that it's because of elderly age or youthfulness that they committed this crime, that you can see that they are capable of living in harmony with society. Now, for a child or a person who's still a youngster, normally they would be diverted. Or in terms of, or in a case where it's an old person, I keep making this example so that you can understand the humanitarian part. It's an old person, they can also be diverted. However, you need to consider the fact that they are old. They are probably receiving a pension. They probably have grandchildren that they're taking care of with this pension and cannot afford the 6-week or 9-week program that the NICRO organization has prepared for them, because now they have to take taxis there to attend all the time. And you see that this person cannot succeed in completing the program, which will result in the the prosecution being forced to reinstate charges against them. So on a humanitarian basis, the matter can be withdrawn that way and can be finalized. And like we said on episode 1, the result is that there is no criminal record, which is also a plus on the side of the accused person. This is not to say that when the matter is going through the representation process or a possible diversion process, that the opinion or stance of the complainant is not taken into consideration, because this is very much considered. The prosecutor, senior prosecutor or control prosecutor, before making such a decision, will usually request the court time, 14 days, to subpoena the complainant to advise them of what the defense or the accused person has requested, which is diversion, and actually ask if they feel comfortable or are happy with this. Now, depending on what the complainant says and the final decision of the senior prosecutor or control prosecutor, the matter may or may not be diverted. But this is one of the many ways one person who's unrepresented can see to a speedy finalization of their matter. Thank you very much for watching.